So, can you start a business in the US on a non immigrant visa? Welcome to US Immigration Simplified. I'm immigration and business attorney Ronald Lee. You can start a business in the US on a non immigrant visa under certain conditions, but the type of visa you hold and its associated restrictions will determine what activities you are allowed to engage in. And here are some key considerations: active versus passive involvement. Many non immigrant visas allow you to establish or invest in a business, but prohibit you from actively working or managing the business without proper authorization. Passive roles, such as being an investor or shareholder, are often permitted. The specific non immigrant visa you hold dictates what business related activities you can engage in. For B1 Business Visitor Visa, you are allowed to research and explore business opportunities, negotiate contracts, attend meetings, or consult with business associates, and incorporate a business or set up a legal entity. However, you cannot actively manage, operate, work in the business. Employment or earning income in the U.S. is prohibited while on a B1 visa. It is best used for exploring or setting up business, but not for operating it. For E2 Treaty Investor Visa, you can actively manage or work in the business you establish or invest in. It requires substantial investment in a bona fide enterprise, but you must be a national of a country that has an E2 treaty with the US, and you determine what these countries are by Googling E2 treaty investor countries. It is best used for foreign entrepreneurs who want to start or run a business in the US. For H-1B specialty occupation visas, you can establish a business, but you must have a valid employer-employee relationship to work for it. Your business can sponsor your H-1B visa if you meet all requirements, including having a board or other entity to supervise you. However, you cannot work for your business unless your H-1B petition is approved. It is best suitable for professionals who want to transition from employment to owning and managing a business. For L1 intra-company transfer visas, you are allowed to transfer to the U.S. to establish a new branch, affiliate, or subsidiary of your foreign company. You can actively manage or work in the new U.S. entity. In terms of eligibility, you must have worked for the foreign company for at least 1 year in the past 3 years. It is best suited for expanding a foreign business in the U.S. For F1 student visa, passive investment in a business is permitted. Certain entrepreneurial activities do curricular practical training, CPT or OPT, if related to your field of study. You cannot actively manage or work in the business unless you have CPT or OPT authorization. It is best for students looking to experiment with entrepreneurship under limited conditions. With O1 Extraordinary Ability Visa, you are allowed to start and work in the business if your extraordinary ability is directly tied to the business activity. Your company can sponsor your O1 visa. It is best used for entrepreneurs with extraordinary qualifications in their field.